你不是不能做这个事。
My Lord, on the day before yesterday, I met a mentioned, brought to my Lord's notice about what is.
Please lift up your mic.
Yeah, am I audible? Day before yesterday, my Lord, I have brought to my Lord's notice what is happening in Northeastern Hill University, where I say that 50s of thousands of students' career are at stake, my Lord. So my Lord has requested me to make a mention today, my Lord. So I have some notifications, my Lord, the exam notifications, my Lord. If my Lord may take so motu cognizance and pass some urgent directions, my Lord, in order to save the careers and the careers of the careers and the interests of the students, my Lord.
But the administration is looking after the matter. We read in the newspaper.
My Lord,
The center.
My Lord, right now, what is happening is the Vice Chancellor, the Registrar, and the Deputy Registrars, the whereabouts are not known, my Lord. The university is left without administrators at all, my Lord. Now, yes, I have come across the government. It's looking, but there's no concrete. So this agitation is not of today, my Lord. It was since October, my Lord. And as the days are passing, it's becoming more and more murkier, my Lord. And just next week, the first semesters are going to start the exam, my Lord.
Central government has authorization. Exclusively. This government has made some recommendation. What is your name, please?
I am Mr. P. Yobin, my Lord. P. Yobin.
An advocate practicing in this court?
Yes, my Lord, yes. As an officer of the court, my Lord, I thought that I'll just bring to the court's notice about this sensitive issue, my Lord, because there are thousands of students' life is at stake. That is, my intention is that much only, my Lord.
All right. Please take down. Suo moto, huh? Mr. So-and-so Yobi, a learned advocate of this court, mentions the affairs of the, what is the NHE full form? University, and requests the court to take suo moto cognizance of the state of affairs and pass appropriate orders. Next, we take judicial notice of the fact that the state government has made some recommendations to the central government to resolve the acute problems which the university is facing today, and that the central government is in the process, that the central government is contemplating measures to resolve the issue. Paragraph. As the administration of the university is in the hands of the government, central government, we are minded to give some more time to the government to resolve the issue, full stop. If the problems persist, we shall actively consider taking suo motu cognizance of the affairs and decide the matter accordingly. List this matter
Nineteenth, 18th to 19th.
20th 20. 20th.
But am I required to file an affidavit, my lord, for central government?
Not now.
Well,
We are not interfering with the matter now.
well,
We are just waiting and watching.
Yes.
After that, we will decide.
My lord. Highly obliged, Lordship.
And you write there, we shall continue to take judicial notice of the developments.
Obliged. Lordship. May I place this notification, exam notification for the reports? My
We are not touching the matter now.
my lord. Obliged.
20th. 20th. 2020.
From supplementary list, item number 1.
Please, Your Lordship. Before my senior starts, Lordship, we are praying for some accommodation. The arguing counsel is indisposed, Lordship.
You are for the appellant?
No, I am for the
The
appellant.
respondent, Lordship.
I am for the appellant. I filed this appeal, Your Lordships, along with an application for stay.
So miscellaneous application is allowed.
Oh.
Miscellaneous application was allowed on that day.
Condonation, my lord. Two applications were filed. One was condonation. On last occasion, Lordship has condoned the delay. So today, appeal has come up along with the application for stay. Now, my lord, I'm seeking.
Lordship, we have some difficulty today, Lordship. The arguing counsel is indisposed.
This is to be heard by this bench? This bench. So then we are sitting again on 20th.
Yes.
20th?
I'm praying for 2 weeks' time, Lordship, because he'll be out of station for medical treatment. The counsel, Lordship.
When?
He'll be out for 2 weeks for medical treatment. So I'm praying for 2 weeks' time, Lordship.
Yes. By consent of learned counsel for the parties. List the appeal and application. On 29 November, Friday accordingly.
Obliged.
Item number 3.
Obligement.
Please, my lords. Lords, I am under instructions that in these set of appeals, my lords, item number 3 of the supplementary list as well as item number 1 to 6 of the main list. Lords, these matters, we are under instructions not to press these appeals anymore. There has been an order passed by the district council, my lords, which puts a quietus to this entire matter.
So, this instantly disposes of 6 matters.
Yes.
Item number?
3 of the supply list, my lords, and item number 1 to 6 of the main list, they all are analogous matters.
Three of the and item number
1 to 6 of the main list, my lords.
These are separate appeals.
These are separate appeals, my lords.
All right. Learned counsel for the appellant submits an instruction that the appellant does not want to prosecute the appeal. Why MC then WA 54? It is,
So let's, in the first matter, there's an application seeking leave. The petitioner's case before your lordships was, my lords, that I was not a
no,
party
these
to this.
numbers are MC numbers or appeal numbers?
MC numbers, my lords. Miscellaneous application, there's an application seeking leave to appeal.
No, that is the 34.
My lords.
And then in the supplementary list, it is WA 51.
My lords. Because there, my lords, they were parties to these proceedings.
These are all miscellaneous cases.
Lordships.
And the appeal number?
Not yet. Appeals have not yet been registered.
Not registered.
Appeals have not been registered.
Not registered as yet, my lords. Because of the application seeking leave.
All right. Now, please take down. Sufficient cause is shown. The delay in preferring the appeal is condoned. This application for condonation of delay is allowed. Give this application, give bracket, give the number in each. We direct the registry to register the appeal. And then give the appeal number. Learned counsel for the appellant on instruction submits that the appellant does not want to prosecute the appeal. Accordingly, the appeal is dismissed as not pressed.
It's one small prayer, my lords, craving your lordship's indulgence. These matters, my lords, are from these little villages. Your lordships have, my lords, it's fallen from your lordships, is dismissed. May I just pray, my lords, that what basically translates to these poor villages is, my lords, dismissed has a different connotation as your lordships would kindly appreciate. May I just pray, my lords, if any
All
other
right,
disposed.
leave. Leave is granted to the appellant to withdraw the appeals.
My lords.
The appeal, it is disposed of accordingly.
My lords. I'll be obliged.
In item number 3, there is no condonation application.
No, my lords, there it is leave, seeking leave, my lords. In the main list, the miscellaneous applications are for condonation of delay.
Then item number 3, the application such and such seeking leave to prefer the appeal is allowed. Then the usual thing, withdrawn, dismissed as withdrawn.
I'll be obliged.
Finished. Then you tell justice being done. 12:15. Finished. So you were right. You were wanting to keep that bench.
from the daily list. Item number 1.
May I please, Your Lordship, I pray that I may be allowed to withdraw this matter and to file afresh, Your Lordship. Will it be to you to file afresh?
What is the defect?
Your Lordship, there are some annexures that are missing, Your Lordship, that it is pertinent to be in this, to annex some important annexures, Your Lordship, that I missed.
This is a writ application.
Yes, Your Lordship. Your Lordship, we're challenging the order of the CAT, Your Lordship.
You may need to withdraw and file a fresh one. Learned counsel for the petitioner submits that there are technical defects in the writ petition and seeks leave of this court to withdraw it and file a fresh one on the self-same cause of action.
Yes, Lordship.
So, paragraph. Such submission is accepted. Next, leave as prayed for is granted. That's all. In the records of this court, this application will be treated as dismissed as withdrawn.
Item number 2.
May it be your lordship, Milord?
Yes.
Milord, this petition I am challenging an order passed by the Commission of Taxes rejecting the refund claim of the petitioner, Milord, after the Cement Sales Act was declared to be ultra-virus and beyond the legislative competence of the state legislature, Milord. Milord, this honorable court declared the Cement Sales Act to be ultra-virus and beyond the legislative competence of the state legislature. However, Milord, this honorable court in the judgment observed, Milord, that the refund which will be granted to those petitioners was made limited to 20% also, and it was also observed that the state relief will be only to the petitioners who were.
Mr. Counsel, where are you stationed?
No, I'm stationed in Guwahati, Milord.
So come and do the matter physically here.
Milord, this is only for the admission notice only, Milord, at this stage.
Maybe. You are not asking for any interim order.
No, Milord, I am at this stage only praying for a notice, Milord.
All right. Then it is all right. What are you challenging in the writ?
Milord, I am challenging the writ, the order passed by the Commission of Taxes, which will also find at page 84. Prior to that, Milord, I may show to your lordship, Milord, the order passed by the Apex Court, Milord, in my SLP, which will also find at page 72, Milord. $75 million. $75 million.
There is no statutory appeal against this order.
No, Milord, there is no statutory appeal.
There is no statutory appeal.
No, Milord, because this is a question of, Milord, the refund was rejected on the ground, Milord, that two grounds, but the Honorable Apex Court held, Milord, that the representation has to be filed and that has to be considered on merits. Your Lordship, can you PS 75?
For the respondents.
Yes, Lordship. Actually, Lordship, the matter has been brought to the senior government advocate, Lordship, but then due to yesterday's thing, holiday, Lordship.
No, but today he wants just formal service of the notice.
But then, Lordship, if I can take the Lordship to page number 72, Lordship, this Honorable Court has already dismissed the matter as not maintainable.
Who has dismissed the matter?
Lordship, this Honorable Court, Lordship.
This self-same matter.
Lordship, can I think which is appealed by to the Supreme Court, Lordship, and Supreme Court has directed the state government to reply to the representation, which was also done, Lordship, and reasonable observations were made, Lordship, by rejecting their representation.
So this is the writ against that.
Lordship,
How can you prevent him?
Lordship,
You are appealing for all the respondents.
Lordship, there are only 3 respondents, Lordship, being the state.
So formal service be waived because he is appealing.
Well, that's a notice may be issued, my lord, because the petition notice may be issued, we'll serve extra copies, my lord.
He is already appearing, so there is no use of a formal notice now.
My lord, because the petition is there unless and until notice is issued to the petition, my lord.
No, please listen to this order. Please take
My
down.
lord.
Since the respondents are represented by learned counsel in court today, comma, issuance and service of formal notice upon them as prayed for by learned counsel for the petitioner is waived. When should we list it for admission?
As your CPG, my lord, after 2 weeks.
All right. List this application on 19 November.
But I think, my lord, they will also file an affidavit if necessary. So they can.
No, first it has to be admitted, then
My
affidavit.
lord.
19th. On 19 November for admission.
If we please, your Lordships.
Yes?
If a small objection may be filed before the 19th.
Why? Let us first admit it then.
Lordship.
If it is dismissed at the threshold, then what we will do with the objection?
Much obliged.
Item number 3.
Yes, please.
May it please, your Lordship. This is a commercial appeal, your Lordship, under Section 37.
Sorry?
This is a commercial appeal, your Lordship, under Section 37 from the Commercial Code.
Section 34.
37, your Lordship. Against 34 had set aside the award. Against setting aside the award, your Lordship, we have preferred a 37.
Union of India has preferred.
No, Lordship, the private party. The award was in favor of the appellant. The Union of India had challenges before the 34. And 34 set aside the award. And Lordship, if we just come to the impugn order, page 70, page 70.
The entire award is set aside.
Lordship, very, very limited ground. The two finding given by the commercial court was, first, there was no reason given by the arbitrator. So the commercial court did not touch into the merit part of it.
You're appearing for?
I am for the claimant, your Lordship, claimant appellant.
For Devali Builders.
Lordship, yes. So if your Lordship comes to, please to come to page 70, para 46.
Seven zero.
Your Lordship. Para 46, 47, Your Lordship.
One, two, five, six, 7 and 8 set aside.
Lordship.
What about 3 and 4?
3 and 4, Your Lordship, we had filed a separate petition. The claimant also had filed an application under section 34 saying to allow to set aside the claim it was not considered. That's a separate misclaim.
3 and 4 were not considered.
Not considered. So we also had filed an application, separate application, Lordship. Now, Lordship, two important finding with this trial court, commercial court, was there was no reasoning given and the counterclaim of Union of India was not considered. I'd like to address that two part, Lordship. Lordship, kindly come to page 65. The same order. Whether reasoning was given or not, on the face of it, Your Lordship, the award will speak for itself. Lordship, I got it, page 65. The third paragraph, Lordship.
Mr. Khan, we have to hear out the appeal.
Lordship, yes. Lordship, only for the purpose, Your Lordship, because this will not require a detailed hearing. It is not the case, Your Lordship, where the commercial court has discussed the evidence on record. Lordship, can you please come to page 65? On the face of it, this will not take much time, this appeal, Your Lordship. Maybe in the next date we can dispose it of. For the simple reason, if we can satisfy the court, Your Lordship. Lordship, we come to claim number 1. 35 lakhs, Your Lordship, this claim number 1. The observation of Lordship, the arbitrator is findings partly justified. And the bottom line, Your Lordship, reason.
Yes.
So, categorically, the arbitrator says findings partly justified, reasons, Your Lordship. The claim is for 35 lakhs, 37,000. After discussing in detail the reason, Your Lordship, I will not take Your Lordship with the details because it's self-explanatory. The learned arbitrator, Your Lordship, before in page 66, before claim number 2, it says, thus an amount of 22 lakhs 74,000 being an aggregate of the 3 items underlined above is awarded in favor of claimant. Lordship, again, Lordship, if I, this is one of the, for one claim, Your Lordship. Now, Your Lordship, if I take Your Lordship to again to the impugn a judgment, Your Lordship, para 46.
Yes, page 70.
Page 70, Your Lordship. A Supreme Court judgment has been quoted, Your Lordship, before each Lordship.
Which is 69, Supreme Court judgment, 69.
Page, Lordship, you come to page 69.
Dyna Technologies, no, sir?
Lordship.
Page 69.
The judgment of Supreme Court, Lordship, starts at page 69. 2019, within bracket 20, Supreme Court. If Lordship comes to page 69. 45, page 69, Lordship, para 35. The Dyna Technologies, para 35 has been quoted. Lordship, just create the leave. Allow me to just read this part, very small part.
We are aware of it, Mr. Khan, that reasons may not be elaborate because they are not,
I'm
they are
grateful.
not jurists.
I'm grateful. Lordship, I'm
But
really.
an indication of how the mind worked reasonably in coming at the decision would do.
Lordship,
Even short reasons would do.
Lordship, I'm relying on the 2010 judgment, Lordship, where a legal mind cannot give. Lordship, on the face of it, no merit was discussed. Only on the ground, there's no reasoning was given and the award was set aside.
Let us see 2.
Lordship will see arbitrated. Claim 2 is at page 66, Lordship. Lordship will kindly see again findings, partly justified reason. Under the reasons, detail has been given. Lordship will kindly come to page 67, claim number 3, reasons, findings, reasons, claim number 4, findings, reasons, claim number 5, finding, reasons are given. Same goes for Lordship, page 68, claim number 6, finding, partly justified reasons. And 7, 8. And Lordship, for a moment, if I take your Lordship to the prayer of the Union of India, I'll come straight to the prayer, which is at page 83. Page 83 of the paper. It is therefore prayed that the Honour may be pleased to set aside the award passed by learned arbitrator as there are basis error apparent on the face of award as stated above, and the award is liable to be set aside. And pending disposal of the petition, setting aside the award, the operation of impugn order, so and so. Also, it is an admitted case of Union of India that the issue of reasoning was never prayed. What they state is an error apparent on the face of record. Lordship, on the face of record, arbitrators, if we go through the award, Lordship, there's been reasoning, there's been justification, and there's been.
What is the total awarded amount?
31 lakhs.
Total.
And this award is of Lordship 30/11/2000, 2003.
And what is the interest granted on the awarded sum?
Lordship, it was 18%. We had paid for 18, but we were given a reasonable. That is at the last page, Lordship.
Awarded the 134 award.
Interest. Last page. 12% interest, Lordship. Page 141. So, Lordship, this is one of the rare arbitration matter where we don't have to go to the merit. It was only the very limited issue, whether there was reasoning or no reasoning, or inadequate reasoning. Our case is very specifically, it is a case of reasoning. It's a case of commercial court completely missing 34 and misdirecting itself. And you also page para 46, the second limb of the argument is, it said the counterclaim of Union of India was not considered. Lordship, if I may submit, that takes care, section 33(4) of the Arbitration Act. Lordship, for a moment, if I take Lordship to the second observation of the Commercial Code, 33(4) of Commercial Act.
Commercial Court, sir.
Section 33.
Claim, counterclaim.
Lordship, 33. Corrections and interpretation of award, additional award. The observation of Commercial Court, the second limb of the observation was counterclaim of Union of India was not considered. Now that 33, Lordship, subclause 4 clearly says, if I may be allowed to read, Lordship.
No. Arbitration Act.
9 भी चला गया ना, 9 है सर, 9 क्लोज 9 ना, सेक्शन 2 क्लोज 9।
वो जो है ना, कहाँ लिखा हुआ है?
हाँ, कहाँ चला?
Section 33.
33, Your Lordship.
34.
Sir, clause 4, Your Lordship. Unless otherwise agreed by parties. Lordship, if I may be allowed to read. Unless otherwise agreed by the parties, a party in notice to the other party may request within 30 days. Lordship, this timing is important, Lordship. 30 days from the receipt of arbitral award, the arbitral tribunal to make additional award, arbitral award to as to claims. Lordship, I'll pause for a minute. Claims presented in arbitral proceeding but omitted from the arbitral award. So anybody who's aggrieved, if any of the claims not considered, it has got 30 days time. So 30/11/2023, Your Lordship, they had 30 days time to move before the arbitral tribunal for consideration. They chose not to, Your Lordship. On 2nd February 2004, they filed an application for setting aside. We are more than 23 years hence. And Your Lordship, if you just clarify the word claims mentioned in 33(4), if I take Your Lordship to the definition of 2, clause 9, section 2, clause 9, Your Lordship. For any claim, the limitation period is 30 days by either party. Now, what would be the meaning of claim? Section 2, subclause 9, Your Lordship. Where this part other than clause A of section 25 or clause A of subsection 2 of section 32 refers to a claim other than those sections, Your Lordship, it shall also apply to counterclaim. And where it refers to defense, it shall also apply to defense to that counterclaim. So, Your Lordship, if you read in harmony, section 2(9) with 33(4), the observation of commercial court, Your Lordship, learned commercial court, that the counterclaim was not considered, hence the award is bad. They had a statutory remedy, 30 days, they chose not to, and they slept over more than 23 years. That could not have been ground. That was an independent claim that can be adjudicated independently. So, Lordship, this two prima facie finding of no reasoning and counterclaim. And Lordship, just I have given a copy, Lordship, just try to rely on one judgment, Lordship. 2010. I've relied on a judgment, Lordship, given the list, 2010.
2010
SSC online, Delhi 29. Lordship, the relevant para 17, Your Lordship, para 3. Para 17, para 3. What had fallen from Your Lordship, I'm just trying to reiterate fortify my argument with the observation, Your Lordship. If Your Lordship has got it, para 3, while from the fourth line, Your Lordship, while observing, so I must note that the arbitrator was not a legal man. In this case also, Your Lordship, the arbitrator was not a legal man, he was an engineer appointed by the Union of India.
Paragraph 17.
17, the third paragraph. Paragraph 17, Your Lordship. The second, it will be second paragraph, Your Lordship, where the word starts from the arbitrator on considering the evidence.
Yes.
The arbitrators, on considering the evidence as available before him, has arrived at a finding by ordering the refund of security deposit. The conclusion of arbitrator in this regard cannot be said to be unjustified or illegal or perverse. While observing so, I must note that the arbitrator was not a legal man, but a technical man.
Yes.
Being an architect, here he was an engineer, one cannot expect such a non-legal person to write and give a judgment like a civil court. So, the Lordship, this judgment is only for the purpose of fortifying the argument on the non-reasoning part. So, Your Lordship, this is a very, very limited appeal, not on the merit, only in the.
There are many judgments of the Supreme Court also on this.
Lordship, yes, Lordship. But this was to the Lordship, but we are coming very close to it. I thought Lordship I should not burden this court because Dyna technologies clearly take care between the distinction between inadequate reasoning and reasoning.
Yes.
In my case, it may be, Lordship, I'm not conceding, but maybe somebody could forward, Union of India could have forwarded an inadequacy argument. But on the face of it, it was a reasoning. So on the face of it, Your Lordship, the commercial court has totally misdirected itself. So the question of coming within the parameter of 31.3, no reasoning, the only limited ground that the commercial court has said, this is in violation of 31.3. And 31.3 of the
Give us the Supreme Court judgments also on this reasoning thing. They have said the reasons may not be elaborate, it can be short, but if it expresses the
Lordship, Lordship, before para 46, Dyna Technologies is the culmination of those judgments, Lordship.
Okay.
Dyna, if I come hurriedly, Lordship, to page 46.
Page 70.
Page 70.
Judgment. Page 70.
Page 70.
70, Lordship.
Page 70 or 46.
The judgment, Lordship, Dyna Technologies has basically addressed that issue, Lordship, para 45. The judgment is quoted with the commercial code itself.
Page 69. Page 69.
That starts from page 69. Sorry, Your Lordship, apology. Dyna Technologies, para 35, Your Lordship, which is at page 69. Had it been the case of inadequate reasoning, Your Lordship, the Honorable Supreme Court is very clear. The court can rely on the records and award should not be interfered. Here is not the case of inadequacy of argument, reasoning. There is a reasoning. So my case still stands on a much firmer footing, Lordship. Lordship, in this view of the matter, there's hardly a very, very limited question of law involved. So maybe today it can be admitted and we can fix a short date, Lordship. It's hardly.
You are appearing for the union?
Yes, sir. Your Lordship, have my land address given. Yes. Yes.
You will be able to conclude hearing today?
No, Your Lordship. Some citations prefer to be given.
Sorry?
Some citations I want to place, Your Lordship, because on the basis of it.
Some citation.
Yes.
18th Monday? But substantial points have been raised.
But it is raised the question this section 33 lordship is just for the moment I can lordship. Section 33/4 is not applicable to us as because lordship it is given if I read as a whole unless otherwise agreed by the parties a party with notice to the other party may request within 30 days from the receipt of the award the arbitration to make an additional arbitration award as to the claim presented. So you will see here, none of our claim has been considered. So this additional arbitration award as to the claim presented, additional, there is no additional because none of our claim has been considered. And if I claim, you will see just for the moment, just because page 134 of this.
Claim is equal to counterclaim, 2 subsection 9. Therefore, a collection of claims and counterclaims are the claims before the arbitrator. If the claims succeed, there is an award. If the counterclaim succeeds, along with the claim, it is set off, one against the other. And if the claim fails and the counterclaim succeeds, the respondent gets an award in his favor. Right or wrong?
This true, you see.
So you have made the counterclaim,
Yes.
which for some reason was not considered. We are not saying that if it is not considered, there is no section 34. But your conduct has to be assessed. That you were given so much time to approach the arbitrator to consider it and to revise the award.
Yes.
But you did not. Now you come before the court when he has filed with an application to set aside the award. There you present that case. How tenable your ground should be to the court.
So you will see here. If I
But
come-
more than that, Mr. Counsel, the most fundamental point is that he has given reasons.
So you will see, just may just come to page 134. May I read you, Lucy?
Yes.
It is paragraph 2 in 134. And whereas I Major General retired C.T. Chari was appointed sole arbitrator in the matters of the Shillong Bench, Guwahati High Court by its order date FU number such and such dated 3rd April 2002 to adjudicate on the claim of list of the 8 claim as intended by the petitioner filed in 28/8/2001. So nowhere in the High Court is given only the 8 claim will be considered. So he has not considered our counterclaim at all, but he has taken and all this in the record. So he confined only the claim of the petitioner, not by the respondent. Had it been given any reason, there is no reason to consider, then matter could have been different. I could have come that this is the mistakes and additional award is required. But none of our claim is considered, you will see. He is limited to the claim of the petitioner only.
Where are your claims?
Here in the judgment, you will see nothing is mentioned. It's silent.
Now you come to the text recital, 1, 2, 3, 4 from the bottom. And whereas I entered upon the reference on 2nd July 2002 and started the proceedings inviting both parties to submit their claims and counterclaims.
Yes, Your Lordship. I filed the counterclaim.
Yes.
So-
You said that he only adjudicated upon claims.
Yes, Your
in the
Lordship.
previous recital,
Yes, Your Lordship.
which you numbered, first recital, that adjudicate on the claimant's list of 8 claims and not on the counterclaims. That was your argument. But thereafter, when it was pointed out that the union also had counterclaims, he has entertained them. You see, at the time of referral, nobody knows whether the other side will have a counterclaim or not. Only the claim of the claimant is referred.
Yes, Your Lordship.
And at the time of presentation of the statement of claim, if the respondent feels no, I will not start a separate proceeding or arbitration, it's a cross suit, that I will present a counterclaim. He has the option.
So, Your Lordship, in this case, as regards the counterclaim, no reasoning is there how he has come to the conclusion about the award.
Any other point you want to argue?
Your
Otherwise,
Lordship,
we will make it CAB.
Your Lordship, this 138. Page 138, Your Lordship. Internal paragraph, page 6. May I read, Your Lordship? The claimant rescinded the contract by his letter dated 8 March 2001.
Which paragraph?
This 130, page 138, Your Lordship.
Yes.
The claimant rescinded the contract by his letter dated 8 March 2001. Then it's given. In the light of foregoing,
Yes.
I, Major General Richard C.T. Theory, do hereby make and publish this award, limiting myself to the 8 claim as petitioner by the claimant to the Chief Engineer in chief and the subsequent to the Honorable Court for reason enumerated earlier as follows. So here, Your Lordship, he has himself is saying he is limited to the 8 claim, no other, and counterclaim has not considered. Your Lordship,
Yes.
if this arbitrator is taken, he is limited himself only for a claim, and he is given and subsequent to the Honorable High Court for the reason enumerated earlier as follows. So he has mentioned this in the High Court also has passed the order. And if we consider here in the 8th claim he has considered on the petitioner, then you will see in arbitration section 33, subsection 4, if I come again, this the arbitration award to make an additional award, arbitration award as to the claim presented. So here you will see where the question of additional award will come up. When arbitrator choose the way,
Where is your counter statement? Where is your counter claim? Was the contract terminated? And the risk purchase made?
so you will say counter claim was there here. Just 292, I think you will. Yes. Yes.
Where is your counter claim?
Yes. I didn't see this one in the part of the record, you will check. I didn't notice in the record, you will say I have to go through. You will say this may not be in the part of the record. In this appeal, I am not getting this one.
Is it page 80, para, it starts from para 17, page 80. Their counterclaim.
This one. This is not the counterclaim.
No, not counterclaim. You mentioned in your petition.
This is the petition claim by utility.
You're 34.
But our counterclaim, our counter is union. Counterclaim.
It is in page 18.
It is not.
In your paper, it is in-
Where do you get the counterclaim?
Your Lordship, counterclaim, it is versus given to the arbitrator. It is not here, Your Lordship. This page 80 is state that whatsoever we have filed the appeal, at that point we raise the objection only this much.
Sorry?
So, Your Lordship, page 80 relates to this matter. That's when this when we have filed the petition at 34. That time they make the ground thereof. But the claim before the arbitrator by the Union of India, it is not here, Your Lordship.
They have also said this was a counterclaim. Yes, set of files.
What was the counterclaim? You see, allowing the claims tantamounts to rejection of the counterclaims. No consideration need have been given. So usually the counterclaim is that wrongful rescission of the contract by the claimant, repudiation, and the damage suffered by the government to get the work done by another contractor. That is usually the counterclaim. So allowing this claim tantamounts to denial of the counterclaim. If that is so, it is all right. You file your notes. No, more or less, you have concluded your submissions. You want to make some more submissions?
Yes, Your Lordship. Yes. Regarding these matters of this.
All right. We admit this appeal by the contractor in a works contract. from a judgment and order of a learned single judge.
It is from this
Huh?
district court.
Oh, sorry. Judgment and order of the learned commercial court at Shillong. Dated 3rd September 2024. What have I said in the beginning? This is, we admit this appeal. This appeal under section 37 of the Arbitration and Conciliation Act. Then from a judgment and order of the so-and-so dismissing the application of the appellant. No, allowing the application of the Respondent Union of India to set aside an arbitral award. Paragraph. You have not prepared any cross objection. You have prepared any cross objection.
Is permitted, sir?
Have you prepared any cross objection in this appeal? That their claims have been set aside, but your counter claims have not been allowed by the judge? No.
So, Your Lordship, this whole award has been set aside, Your Lordship. So, when award is set aside, so there is no.
No, there was no award with regard to the counter claim.
As regard to the counter, there is no award. So, we prefer the appeal for set aside the award. So, award has been set aside as a whole.
What has been set aside? Claim numbers 1, 2, 3, 5, etc.
Yes, Your Lordship.
But there is nothing about the counter claim. Whether the counter claims were allowed, disallowed, etc. You have not prepared any cross objection.
So, Your Lordship, we have filed the appeal for set aside the whole award. So, this is the common judgment given in this case in respect of our petition.
Appeal they have prepared. Yours was section 34,
Yes, Your Lordship.
where the award was set aside.
Yes, Your Lordship.
The award was set aside, that is all right, the award in their favor. But that the counter claim in your favor was not allowed, that was not challenged?
No.
That was challenged in the 34, but there's nothing in the impugned judgment at all. So you have not prepared any cross objection? Anyway, so Mr. Khan, Learned Additional Advocate General.
Lordship, I'm appearing in an individual capacity. Lordship.
It's all right, but you are additional Advocate General with the right to appear for. So that there is no problem.
Obliged.
Appearing for the appellant. Has made and concluded his submissions. List this appeal on 18th. to hear arguments on behalf of the respondents. Learned counsel are requested, if they so desire, to bring written submissions
Lordship, yes.
annexing copies of judgments proposed to be cited or proposed to be cited
Online.
on that day.
Item number 4.
Hello, Professor.
Yes. Let's keep this up. Yes.
In this matter, my lord, we will need to file a rejoinder affidavit to the reply.
Rejoinder?
My lord, I'm praying for another 1 week time. My lord.
All right. List is public interest litigation on November 22nd. Rejoinder may be filed in the meantime.
Yes.
Next.
Item number 5.
My lord, we've taken steps for notice, my lord, but the ID card has not come till now, my lord. I'm praying for some more time, my lord.
All right.
Just attend from the post office.
Service report is awaited. List this miscellaneous application. On 19th November.
Right. Right.
Item number 6.
Your Lordship, I'm appearing for respondent number 3 on behalf of my senior K.C. Gautam.
Senior?
My senior
Who is
K.C.
it?
Gautam. And he has been hospitalized and he is on sanction leave. And now I'm praying for accommodation, Your Lordship. Let this matter become after 2 weeks, Your Lordship.
Yes, Mr. Yabin.
My lord, no problem because he's been hospitalized as I was being informed.
How much time do you require?
2 weeks time, Your Lordship.
All right, on the medical ground of learned counsel for the respondents and with the consent of
This is amicus, my lord.
yes, with the consent of the amicus curiae appointed in the matter. We adjourn this application. December.
Obliged.
Your Lordship.